My father-in-law died on a Tuesday in November. The kind of gray, bone-cold Tuesday that felt like the whole sky had given up. I remember standing in the funeral home parking lot, breathing in frozen air, watching my mother-in-law dab at her eyes with a tissue she'd already used 3 times. My husband stood beside her, one arm around her shoulders. I stood a little behind them, as I always did in that family, present, but not quite part of the picture. His name was Walter. He'd worked 40 years as a machinist in Hamilton, saved every dollar he didn't spend on rent and groceries, and somewhere along the way had accumulated a small but real estate. A detached house in Burlington, a TFSA with about $340,000 in it, and a basement full of tools, so organized it looked like a museum. He was quiet, methodical, and deeply fair. He told me once, over coffee at his kitchen table while my mother-in-law was at her book club, that he'd always intended to divide things equally. "You've been good to my son," he said. "That means something to me." I didn't know, standing in that parking lot, that those words would become the most important thing anyone had ever said to me. The will reading was 2 weeks after the funeral. My brother-in-law, my husband's older brother, who'd moved back to Burlington 3 years earlier after a business in Calgary failed, sat across the table from the lawyer with an expression I'd seen before. Relaxed. Too relaxed. The kind of relaxed that means someone already knows what's coming. My husband and I sat together. The lawyer, a woman named Ms. Hartley from a firm on Brant Street, opened the file and read. Walter had left the house to both of his sons jointly, to be sold within 18 months of his death. Proceeds split equally. The TFSA, which, under Canadian law, passed outside the estate, had been set up with my mother-in-law as the sole successor holder. That was expected. But there was a second account, a non-registered investment account with about $180,000. That one was split 3 ways, 1/3 to each son and 1/3 to me. I felt my husband's hand tighten on mine. My brother-in-law didn't say anything during the reading. He thanked Ms. Hartley, he hugged his mother, he shook my husband's hand. He didn't look at me once. That night, he called my husband's cell phone and talked for 45 minutes. I was in the other room, loading the dishwasher, and I couldn't hear the words, only the rhythm. Long stretches of my brother-in-law's voice, then short responses from my husband, then more long stretches. When my husband came to the kitchen doorway, his face was careful in a way that worried me. "He thinks Dad made a mistake," my husband said. "He thinks Dad meant to leave your share to Mom." I dried my hands on a dish towel. Ms. Hartley read the will. It was dated 8 months ago. I know. Did he say what he wants to do about it? My husband looked at the floor. He wants us to sign a deed of family arrangement, redistribute your third back to the estate, then to Mom. I put the dish towel down very carefully on the counter. "And what do you think?" He didn't answer right away. That was its own kind of answer. "I want to be clear about something. I liked my mother-in-law. She brought us soup when I had pneumonia. She remembered my sister's birthday. She was not a cruel woman. But she was a woman who had, for as long as I'd known her, operated according to a quiet and unspoken rule. The family was her 2 sons and herself. And I was the wife, which was adjacent, but different. I was the woman who'd taken her younger son to Toronto, who worked long hours at a hospital administration job she didn't fully understand, who didn't know how to make the butter tarts my husband had grown up with. I had spent 8 years trying to earn my way into that family. Walter, in the end, had simply given me a place in it. I was not going to sign it away. I told my husband that night, calmly at the kitchen table, with my tea going cold in front of me. I said that I understood. If he felt pressure, I understood the family dynamics, but I was not going to waive an inheritance that his father had deliberately and legally chosen to leave me. I said we could talk about how to handle his brother, we could involve a mediator, but my name was not going on that deed. My husband nodded slowly. He said he understood, and I believed him then. Things moved quietly for a while. My brother-in-law stopped calling as frequently. Christmas was strained, but survivable. My mother-in-law made the butter tarts, offered me one, and when I smiled and said thank you, she smiled back, and it almost felt like things might be okay. In February, Miss Hartley's office contacted us about the estate administration timeline. The house needed to be listed by May under the will's terms. My brother-in-law was handling the listing. He'd suggested it, said he had a contact, said it would be easier if he managed the process and reported back to my husband. My husband had agreed. I asked to see the listing agreement. My husband said he'd ask his brother to send it over. A week passed, then two. When I asked again, my husband said his brother was still getting it organized, and there was something in the way he said it, a flatness, a practiced quality that made something cold settle in my stomach. I called Miss Hartley myself. She was professional and careful. She said she could not share documents relating to the estate administration without the consent of the estate trustees, my mother-in-law, and my brother-in-law, as Walter had named them, but that if I had concerns, I was entitled to consult my own counsel. That was the moment I understood that this had already moved past a family disagreement. I want to tell you something about what it's like to be in this position. You are in a house you share with someone you love. You are eating dinner at the same table, sleeping in the same bed, and you are also, quietly, separately, becoming aware that the person sitting across from you knows something you don't, and that the thing they know is not small. I did not want to believe my husband was deceiving me. I kept searching for another explanation. The generosity of ambiguity is something you cling to for as long as you can. I gave it 4 more weeks. Then I found an estate lawyer of my own, a man named Mr. Okafor practicing in Oakville, who came recommended by a colleague at the hospital. I sat in his office on a Wednesday afternoon and told him everything. He listened without interrupting. Then he asked me several very precise questions. Had I signed anything? No. Had I received any distributions from the estate? No. Was I aware of any property transactions? I said I didn't know. He said, let's find out. Under Ontario's land registry system, property transfers are public record. Mr. Okafor's office ran a title search on the Burlington house the following day. The house had not been listed. The house had been transferred 2 months earlier, in December, via a survivorship deed filed by my mother-in-law and my brother-in-law, removing the property from the estate entirely and vesting it jointly in their names. My third of the investment account, which should have been distributed within the estate process, had not been paid out. No check, no communication, no record of intent to pay. I sat in Mr. Okafor's office and looked at the land registry printout and thought about my father-in-law at his kitchen table, saying that means something to me, and I felt something happen inside me that I can only describe as a door closing. Not slamming, just quietly, firmly closing. I asked Mr. Okafor what my options were. He explained that what had been done with the house, removing it from the estate via a retroactive deed without the consent of all beneficiaries, was not legal. The survivorship mechanism they had used did not apply to this property structure. More importantly, the estate trustees had a fiduciary duty to all beneficiaries, including me, and had demonstrably failed to fulfill it. This was not a gray area. This was estate fraud. He asked me how I wanted to proceed. I said I wanted to proceed correctly. I wanted every step documented. I wanted no communication from me to them until he told me it was time, and I wanted whatever outcome this produced to be so thorough and so clean that there would be nothing left to argue about afterward. He looked at me for a moment. Then he said, I can work with that. I went home that evening and made dinner. My husband asked how my day was. I said fine. I asked about his. He said busy. We watched something on television and I don't remember what it was. I remember thinking, with a clarity that was almost peaceful, that the next several months were going to change everything and that there was nothing to do now but let them. Mr. Okafor filed a notice of objection with the estate on my behalf, which legally required the trustees to halt any further distributions or transactions pending resolution. He also filed an application with the Ontario Superior Court of Justice to To have the December property transfer set aside on the grounds of breach of fiduciary duty and failure to administer the estate in accordance with the will. My brother-in-law called my husband the day the notice was received. I heard the phone ringing, heard my husband go into the study, heard the door close. When he came out 40 minutes later, his face had a look I'd never seen on it before, something between shame and resolve, and I still don't know which one won. He said his brother was very upset. I said I imagined he was. He said his brother felt I had gone behind the family's back. I put my book down. I said, "Your brother filed a deed that removed your father's property from your father's estate 2 months after your father died." He did not tell me. He did not tell Ms. Hartley. "He has not paid me the inheritance your father legally designated for me." I hired a lawyer. That's not going behind anyone's back. That's responding to what was already done. My husband sat down. He was quiet for a long time. Then he said, "I knew about the deed." I had already known that he'd known. I'd known for weeks. But hearing him say it was different from knowing it. I nodded. I didn't say anything else that night. What happened over the next 3 months is something I'll compress for you, because living through it was already exhausting, and I don't want to exhaust you with it. There were affidavits. There were counterfilings. My brother-in-law retained a lawyer in Hamilton who sent a letter arguing that Walter's intent had been misrepresented in the will and that the bequest to me was the result of undue influence. They did not specify who had exerted this influence, only that it was suspected. It was the kind of allegation that costs nothing to make and is designed to tire you out. I was not tired. Mr. Okafor responded to each filing methodically. We had a handwritten note Walter had left with Mr. Hartley at the time of the will drafting, not legally binding in itself, but clarifying, in which he'd written, in his neat machinist's handwriting, that he was leaving a share to me specifically because I was a full member of this family and should be recognized as such. Ms. Hartley had kept it in the file. My brother-in-law's lawyer had apparently not known it existed. There was a settlement conference in April. I sat on one side of a table in a boardroom at a courthouse in Milton. My mother-in-law sat on the other side and did not look at me for the first 45 minutes. My brother-in-law sat beside her, very straight, very contained. His lawyer whispered something to him at one point, and he shook his head slightly. The mediator was a retired judge, methodical and patient. He walks through the documents. He asks questions. At about the 90-minute mark, he looked at my brother-in-law's lawyer and said plainly that the December transfer was not going to survive judicial review, and that the question before everyone was whether they wanted to spend another 8 months in court to confirm that outcome, or whether they would prefer to resolve it here. There was a long silence. My mother-in-law said quietly that she wanted it to be over. My brother-in-law looked at his hands. The settlement took another 2 hours to finalize. The December transfer was unwound. The Burlington house went back into the estate and was listed the following month. It sold for $940,000. This is Burlington. This is what houses cost. And after legal fees and the mortgage discharge, the net proceeds were split as the will directed. My husband and his brother each received their share. My investment account distribution of $180,000 less applicable withholding was paid to me in full by certified checks 6 weeks after the settlement was signed. My mother-in-law and I have not spoken since the settlement conference. My husband and I are still together. I want to say that clearly because I think people expect this kind of story to end a marriage, and maybe it should have, and maybe we are still working out whether it did in some way that doesn't yet have a name. He did not engineer what his brother did. He knew about it and said nothing, and those are different things, though they are not unrelated things. We have talked about it more times than I can count, in the way that you talk about something that doesn't fully resolve. You just find different ways to hold it. What I think about more than the money is the note in Ms. Hartley's file. Walter, sitting across from her, probably in his good jacket, writing in that careful handwriting that I was a full member of this family and should be recognized as such. Writing it down, because he understood that words spoken across a kitchen table can be forgotten or denied, but words written in a lawyer's office become something else. He knew. He knew what his family was capable of, and he made sure it couldn't be undone. I think about that kitchen table conversation sometimes. He'd poured us each a coffee without asking because he'd already learned how I take it. He knew I take it black. That small thing, that quiet attentiveness, meant more to me than I ever told him. I wish I had told him. I don't argue about it anymore. I don't replay the settlement conference or rehearse the things I could have said to my brother-in-law or wonder what my mother-in-law thinks of me now. What I know is this: someone saw me clearly and wrote it down, and when the moment came, it held. That's enough. That's more than enough. I keep coming back to that note in Ms. Hartley's file. Walter writing it out by hand, careful, deliberate, the way he did everything, saying that I was a full member of this family and should be recognized as such. He didn't have to write that. The will was already legal without it. He wrote it because he understood something I was still learning, that doing the right thing isn't enough on its own. You have to build it so it holds. That's what I think about when people ask me how I got through those months. It wasn't one big decision. It was a series of small ones, each requiring something slightly different from me. Restraint, when every instinct said to confront. Clarity, when the people closest to me were muddying the water. Steadiness, when the process was slow and the uncertainty was exhausting. None of it was dramatic. Most of it was just showing up, again and again, and refusing to act from panic. My brother-in-law made choices that were driven by fear and greed, and those choices compounded on each other the way that kind of thing does. One transfer led to a cover-up. The cover-up led to delay. The delay led to a courtroom. He didn't start out thinking he'd end up in a settlement conference being told by a retired judge that his position wasn't going to survive review. He got there one small, dishonest step at a time. I've thought about that a lot, how the same incremental logic works in reverse. One honest step at a time, one documented conversation, one consultation with a lawyer, one decision not to sign something you shouldn't sign. The outcomes accumulate just like the mistakes do. What Mr. Okafor gave me wasn't just legal strategy. It was a framework for thinking clearly when I was frightened. He asked precise questions. He looked at documents instead of feelings. He reminded me in the most practical possible way that my instincts were worth trusting if I was willing to do the work to back them up. I didn't walk into his office knowing what to do. I walked in knowing something was wrong, and that turned out to be enough of a starting point. My husband knew about the deed and said nothing, and I've had to sit with what that means without letting it calcify into something permanent. That's its own kind of work, the work of staying honest about someone you love, not softening what they did, but also not reducing them to it. I don't think I finished that work. I'm not sure it finishes. Walter left me something I didn't expect, and it wasn't the money. It was the evidence that someone had looked at me clearly and decided I was worth the effort of a considered, deliberate act of fairness. That's not a small thing to carry. It changes how you see yourself, and it changes what you're willing to accept. I don't argue about it anymore. But I think about that kitchen table, the coffee he poured without asking, the handwriting in the file. He saw me, and he made sure it counted.